Hello and welcome everyone to what we hope will be an interesting interaction between our accomplished guests today. Firstly, a brief introduction of myself. The title of this event suggests that I'm seasoned, which I take to be a polite way of saying I'm old. But it's also fitting as there's rather more salt than pepper in my hair these days. I've been active in the construction industry since 1971, and for the past 15 years, I've been fortunate to have specialized in the production of claims for international contractors and representing them as counsel through the whole process of dispute resolution. As one of the senior contracts advisors for the sponsor of this event, Techno Engineering and Associates Group. Our guests today are Florin Niculescu, a successful dispute board member and freelance consultant. And we also have with us Giovanni di Folco, the president and senior partner of our sponsor, Techno Engineering and Associates, who is, dare I say, seasoned, a FIDIC accredited adjudicator and an expert in project and contract management, contract administration, claims preparation and defense. With introductions behind us, I would like to pose a multifaceted question to our guests, hopefully for debate. These are free discussions and open opinions, not to be taken as legal advice. At the end of the session, we invite questions or comments to our guests from viewers, if they have any. So my question to our guests is, how inquisitive should a dispute board be with relevance to a somewhat recurring controversial issue related to delay analysis in support of contractors' claims for extension of time and money? What I mean by that, it raises a number of aspects to be considered. I will go through these because these are the root of the questions, really. Should the DB carry out its own delay analysis to the extent of correcting errors, if any are found, that is, in the contractor's baseline program and/or delay analysis, in order for the DB to be able to provide a reasoned decision on the extension of time entitlement to be decided by the DB? Or, whilst being aware of errors in the contractor's baseline program and/or delay analysis, should a DB assess the EOT entitlement on the balance of probabilities and the evaluation of the evidence before the DB at face value and give a decision accordingly? Or should a DB point out the errors to the parties and request the contractor to correct the errors and resubmit the results by obtaining the parties' agreement to extend the time for the DB to give its decision? Or should a DB obtain the parties' approval for the DB to appoint its own independent expert in delay analysis and request the expert to confirm the existence of the errors and correct them while performing its own delay analysis in an advisory manner to support the DB in its decision-making process? Or should a DB reject the contractor's claim on the grounds of erroneous supporting particulars and decide on zero EOT and entitlement due to the contractor's failure to prove its case? I throw it open to whoever wishes to go first.
Well, Giovanni, I think that should be you to start.
Thanks, Clive. This is quite a hot subject, which has been recurring for years, and as adjudicators, it is nothing new. However, it is correct that you stated that it's controversial. It is. I think for the audience, it will be good to know that my esteemed friend and colleague, Florin, and I, we have not rehearsed for this, just to come up with our own points of views, which might be completely opposite, so that we can create a lovely atmosphere of debate amongst two seasoned adjudicators.
Contradiction generates the truth.
Most probably the truth. I mean, we are supposed to always say the truth. This is our profession, based on the facts, though. So you don't mind for me to go first? age.
By all means, by all means.
I can certainly.
We take each question one at a time.
I can certainly repeat the questions as may be necessary, so there's no problem there.
Okay, perfect. So Giovanni, please, the floor is yours.
Look, as a first reaction, I would say it all depends on the dispute board's background, whether it's a sole member or it's a panel of 3 experienced adjudicators. And also depends on the extent of the delay analysis that forms part of the referral to the dispute board for decision. However, I am of the opinion that if the DAB possesses the required skills in delay analysis, and there is a reasonable available time within the 84 days for deciding on a dispute, which it may appear to be quite a long time, but it is not actually, when it is considered that the parties, as allowed by the DAB procedures, will exchange, albeit within a short period of time, their pleadings, like a statement of claim and statement of defense, and then rebuttal and rejoinder. If, however, the DB has those skills, I am of the opinion that through his assessment of the evidence before the board, he could try at least to carry out a high-level delay analysis. And then if he sees errors, I see nothing wrong for the DAB to fix them in order that the dispute board will feel comfortable as to the number of days that will have to be awarded to the claimant in respect of EOT entitlement. I believe that such an approach will be within the dispute board powers, which are bestowed onto the dispute board by the parties through the dispute adjudication agreement or dispute board agreement, depending on which conditions or contract are used. And I think that all our discussions will be based on FIDIC conditions of contract, because these are the most used internationally. And I will basically use the FIDIC pink book as a point of reference, just that it's easier because it's on my desk. If we look at the FIDIC pink book and we go to page 76 and 77, there are rules that apply to the dispute board. And I see 3 very important rules in respect of the subject matter of this debate. And these are B, D, and E. If I read in turn each of them, it says that the employer and the contractor empower the dispute board, among other things, to B, decide upon the dispute board's own jurisdiction, and as to the scope of any dispute referred to it. D, for David, says take the initiative in ascertaining the facts and the matters required for a decision. And E, make use of its own specialist knowledge, if any. This dispute rules, empower the DAB, in my view, in this scenario, to perform its own delay analysis to arrive at a decision on what would be the reasonable number of days of extension of time to be awarded to the claimant most probably that will be the contractor in this case, and as basis for compensating the claimant if quantum is also sought as part of the referral to the dispute board. Now, these are three of the several rules that the FIDIC Pink Book contains in the annex to the conditions of contract and to the general conditions of contract for the dispute board. If I take a few minutes and I examine each of these rules one at a time, I see that basically in respect of rule B, if the scope of the dispute is one where the parties disagree with the number of days of the contractor's EOT entitlement, then when the DAB under this rule will decide on its own jurisdiction, it will have the power to decide, I believe, that it can prepare its own delay analysis to test the veracity of the contractor's delay analysis in disputes between the parties, because that is the scope of the dispute. The scope of the dispute is set out within either the notice of dispute or the actual referral document that we all affectionately know as a statement of case or statement of claim. And in there, the scope is defined and also the jurisdiction of the DAB is established. What the rules do, it just widens that jurisdiction and allows obviously very large powers to the dispute board to decide on his own jurisdiction and as to the scope of the dispute. Rule D, in turn, allows the dispute board to be inquisitive by applying an inquisitorial approach to the dispute, to the way the dispute board wishes to establish the procedure to be applied in deciding the dispute. Now, the inquisitorial approach that the dispute boards are empowered with is something unique. As a matter of fact, arbitrators do not have such powers. They do not require to be inquisitorial. They have just to decide on the facts before them, and that's it. The dispute board has this wonderful tool at its disposal to actually go in to the matter in dispute and decide what to do in order that he will better assess the facts and the evidence before the dispute board. And these allow the latitude that if under Rule E, for instance, the DAB makes use of his own specialism, and that in this scenario would be a knowledge of delay analysis, either as an expert in delay analysis or as someone that is very competent in delay analysis. Well, that will allow the DAB to do at least a high level delay analysis in control of what has been put as evidence before the dispute board. And that will obviously allow a decision that it's well reasoned, because the evidence is not taken at face value, but it is tested, whereby under the inquisitorial role of the dispute board, they can put questions to the parties several times after each submission is effected. And this is the beauty of the procedure. If it's well managed and the timing for the parties to reply to each other and to submit the defense, it is reasonably adjusted to the 84 days and the possibility that the DAB wishes to perform its own delay analysis, whether to a level of details that normally would allow the dispute board to be comfortable with the results, it will, in a way, create that balance of probabilities that it is required under dispute adjudication to actually ascertain the evidence in a far more in-depth manner that the 84 days would normally allow, which obviously is a luxury that dispute boards do not have. I mean, this is not arbitration where it may take years to listen to the parties' positions and then issue an award if you are an arbitrator.
Giovanni, if I may intervene, please.
84 days is actually, as you know, Florin, it runs every day on you, and there is a lot of work that the board has to be done. And if you are a sole member DAB or dispute board, that becomes an enormous task to fit that in. So I go back again. It depends on the complexity and how the length of time for the analysis. If it's a year that has been analyzed and the EOT thought it's reasonable in the 50 or the 60 days, I think that can be managed. Obviously, if it's too far from the facts, and this comes as a very large claim after 3 years of construction, and is sent to the DABs with thousands of pages of delay analysis, then obviously this application would not be possible. If we look at the question, obviously we have to look at the possibility that the dispute board will not have the skills to perform a delay analysis. That should not discourage the board to discuss with the parties about the appointment of an independent expert. And the dispute board should be experienced and clever when entering into a tripartite agreement with the two parties to ensure that that aspect of the board requiring at some point independent expertise is not something novel or something that will be put in front of the parties during the 84 days, and obviously they may have some issues that may not go down well with the parties. If the possibility is discussed at the time that the dispute board agreement is discussed and agreed, that becomes kind of a baseline, if you will, so that when the dispute board, which is not expected that a board is experienced in every aspect of engineering or in every aspect of law, or you may have a dispute boards that is non-engineering based. You may have quantity surveyors or lawyers on the dispute board, and not the engineers that is specialized in that type of construction and has obviously the planning background. In a case like that, I believe that if the DAB has paved the way from his appointment to the ratification of that appointment through the dispute board agreement, and then to obviously the proper approach to the parties during the referral period of time, I cannot see the parties disagreeing that easily to a request from the board in that regard. What happened when all that fails? Well, that becomes complicated, because if the DAB with some degree of analysis has arrived, or the respondent for that matter has put forward to the dispute board that the board should be aware that their analysis in defense considers the delay analysis flawed in respect of some aspects and having errors and identifies those errors. So the dispute board can be put on notice that there is an error and maybe can look into that direction and ascertain that error for themselves. Then one way of avoiding that there is an abrupt decision, a guillotine type decision, the board can discuss with the parties to allow additional time for the decision in order that the contractor can fix those errors and resubmit, for instance, a window that has a specific error. Obviously, if the whole analysis flowed, then case closed. I mean, there is nothing that can be done. One thing I, as an adjudicator, always profess to be a proper approach is that in a case like this, and everything else has failed, I would recommend to other adjudicators to decide at least on the merits. Is it contractually sound, the request for extension of the time? Have notices been given on time? There are no issues about the contractual clause that would allow the extension of time to be given. And decide on that so that the entitlement stays. And then obviously in the decision tell the parties that the dispute board could not, with the evidence before him and the errors identified and the issues being created by the parties that most probably did not want any appointment of independent expert or allow additional time to the 84 days for the contractor to fix its errors, at least that will open the door for the claiming party to go back, fix his delay analysis, and then discuss it again with the engineer and the employer in order to seek an agreement to a certain extent. If that fails, then that will be a dispute that can be refiled to the dispute board, and there will not be the danger of the dispute board being functus officio because it has already decided on the matter. If the decision is well written and it says that it is only on the merits that the entitlement to an extension of time is given, however, no time is decided due to the insufficiency of the evidence before the DAB, then the DAB will have jurisdictions in the second round. This, in a nutshell, what I see as a situation in response to your scenario, Clive. Florin, by all means, if...
Thank you. Well, generally, I do agree with you, but coming from some highly tensioned experience, if I may say so, with some highly controversial parties, I think certain precautions should be looked at. While I do agree that a DAB always have the power to decide on their limit of jurisdiction and so on, and they can go ahead and do certain checks and do their own time analysis, I fully agree with that. But firstly, the very first thing we should underline, in my opinion, is the fact that the DB is not there to be the advocate or not even to be perceived as being the advocate of any of the parties. That is very important, that the DAB is always seen as being impartial and not doing the case for any of the parties. That is very important. First thing. Secondly, it depends on how large that time analysis is, which is to be verified by the DAB. Because if it's a very large one with a lot of input data based on a lot of records, then that in itself becomes a job for months. Mm-hmm. And most probably, in most of the cases, the DAB members will not be highly specialists in this field. Yes, the DB members will most probably be able to analyze and eventually identify certain aspects which need additional clarification. And yes, by all means, I believe it is their duty to clarify these, to go inquisitorial and put to test all these apparent or obvious inconsistencies in order to make sure that they clarify everything as much as they can beyond any doubt. But we have to remember that the burden of proof is with the one that is making the claim. Coming to what you said, if the respective, let's say, the claimant, the respective claimant is not providing sufficient evidence and is not managing to answer in a satisfactory manner to all the questions of the DAB, then the DAB, yes, will decide on the merit and will also decide a number of days for the EOT as much as it is demonstrated by the time impact analysis provided by the contractor and by the clarifications which were subsequently provided. But all in all, yes, the DB can make their own analysis, but we have to all be aware of the time constraints. And also it depends very much on how much the parties are willing to eventually give some additional time, which generally it may not happen. And the last but not the least, if the DB members are making their own time impact analysis, mind you, they are under the pressure, the time pressure, and not only, they might run the risk of making themselves eventual mistakes, and then they will putting themselves in front of the firing squad. So in conclusion, yes, I agree with you, but I would also draw the attention on certain precautions that might be needed to be taken into consideration before going into a deep time impact analysis. This would be my opinion for this, for the first point which Clive mentioned. If you want, I can pass to the second one, or if you want to develop with the second point, to point out the errors.
You made all valid points, Florin, which I agree. One thing that obviously can help a situation like this, and this is basically based on past experience, is that with agreement of the parties and the proposal of the dispute board, the referral can be bifurcated, whereby the merits are decided in the first phase, and then a second phase will decide on the quantum of the time and money, which obviously would allow more time. If the parties are reasonable, it happened, and that allowed adequate time to the DAB other to perform the analysis.
It's a very good point to make, Giovanni, because as you well know, that we have some very big cases that we put to DABs, and even when drafting statements of case, you almost feel guilty that you're giving the DABs such an awful lot of work to do in a short time. And bifurcation is a very good way of splitting the merits from the final decision, and in a way it can save an awful lot of work, which is time and which is money, for the parties in the event that the merits may be on rather shaky ground, and you may have a decision against the claimant on merits, which would waste all the time of going through the supporting particulars for quantum and time-related awards. Shall I move on to question 2?
Very good points, Clive, before you move on question 2, because it is indeed the duty of a dispute board to streamline the procedure. I mean, if it fails on the merits, no matter if the delay analysis was prepared by a genius, whether it was perfect or have some aspects that obviously need to be reworked, you know, the case is dead there. So I think the bifurcation, it's always a viable solution. The only problem is that it interferes with our ethical duty to provide a decision by economizing on time and cost. Obviously, bifurcation will extend the time, will extend the costs, and there has to be a trade-off that needs to be applied, if you may. Florin, I don't know, how do you see that bifurcation from your side?
In my opinion, it might not be as possible in the case of adjudication, at least under the FIDIC rules, simply because there is one referral and there should be one decision. There is no procedure, there is no rule which would allow to have a two-phase dispute resolution process, which in my opinion would be great indeed. If the merit is failing, then obviously there is no point wasting time and resources to go in a deep analysis of the quantum, by all means. And in my opinion, the only thing that can be done by a adjudicator with a reasonable common sense is to first verify the merit. And if in his opinion, he will be convinced that the merit is failing, okay, he will make some further questions, but in order not to decide in advance, let's put it that way, in advance of issuing his decision and not be perceived as such, he may raise some additional questions about the quantum just in case. But otherwise, the analysis should be rather dropped. And when you know that clearly the merit will be failing, then there is no point in wasting more time and money for the parties to go in a deep analysis of the quantum.
We have one example, or I have one example, where we asked for the decision to be bifurcated. The referral was a single referral, but we asked for the decision to be bifurcated with the merits first, followed by, in the event that the merits were in the favor of the claimant, followed by a decision on the quantum of the claim. And that worked very well. In our case, we actually won on the merits, and therefore the DB could step into the second part. And he treated it almost like a separate referral, because we had another hearing dealing only with the quantum aspects stemming from the merits that he had already decided upon. So it's only the decision that was bifurcated, not the actual referral. But the process was run like two separate DABs.
But in that case, if I understand correctly, there was an agreement of the parties to proceed that way. And in that case, you had two wise parties, which is a rare case.
Yes, there were other rarities about that DB. It was a panel of 3, but they actually proposed a protocol which dealt with a lot of these issues to the parties before they signed the agreement, the tripartite agreement.
Yeah, that's a clever way of doing it.
Very well indeed. So really the scope that DBs have, I think, is far wider than people may think if they don't have much experience in a variety of cases. It looks very rigid when you read FIDIC and what the DBs are obliged to do and what they're able to do, but you can actually stretch this to quite wide variety of changes with the agreement of the parties, of course.
I absolutely agree. And indeed, as I mentioned earlier, at least according to the FIDIC, there are not such procedures for bifurcation. But if the parties mutually agree on various aspects, then yes, they can definitely do that. And obviously it's for their own best interest.
Absolutely.
I would definitely be most happy to have these kind of parties in an adjudication that would accept to collaborate from this point of view and make the things easier and less costly for themselves. And yes, it is possible if the parties do agree to do that way.
We're very used to parties literally falling out prior to a dispute going to an adjudicator, so they just don't speak to each other anyway. And even if they do, they're spitting at each other instead of trying to work together. So yeah, there's every scenario here, and I think anybody listening to this that has no experience with DBs, my advice to them would be the rainbow of options is much wider than it may appear to be, as long as you don't transgress the hard rules that are in the DB section of FIDIC.
I absolutely agree.
No, I agree with you, Clive. It is interesting, you know, this kind of discussions. Clive being the moderator, but having as a background his counsel role. I mean, Clive acts as counsel in dispute adjudication and in arbitration. So obviously he deals with dispute boards from the side of a counsel that is presenting a case for one of the parties, or which is either prosecuting it or defending it, depending if he's acting for the claimant or the respondent. How do you see, as a counsel, the position of the board that is trying everything possible to provide a reasonable and fair decision by obviously structuring the time available in such a way that a matter that instead to be left as a drop dead matter, it actually can be dealt with and really investigated. How do you see it from a counsel point of view?
My view is that the DB is there by the agreement of the parties. It's in the contract. They've already agreed that they will have their disputes adjudicated by a DB, and therefore you have to respect the DB's positions, and you have to respect the complexity of the case that you're putting before them. I don't think we've ever put absolutely simple cases in front of DBs. They've always been very complicated, because it's the complicated issues that cause the disputes. The simple ones you can resolve between engineer and contractor. It's something that you can deal with on the site. But the complicated ones, and really there is no extension of time which is absolutely simple, or it's a very rare occasion, and I'm sure that the parties would agree on a case like that without going to adjudication. But when it gets complicated, I mean, we've had over 150 delay events on some of the cases that we've taken to DB, and this is a monster to put in front of a DAB. So you've got to respect their position, you've got to respect the difficulties they're facing and try to help them through, not only as claimant so that you get a good decision from them, but in my view, half of the representation for the claiming party is in a defensive role anyway, because the responding party will always attack you at any opportunity. So you end up defending as opposed to attacking in a claimant's role. But I think you've got to respect the job the DAB is faced with, make it as easy for them as possible, and assist them when they ask for help. And very often they do ask for help. They literally go to the parties and say, we have a problem here, we need a way to get through this, can I have your agreement to X, Y, and Z? And in most cases, the parties are very cooperative to agree. When approached by the DAB, they can't agree on anything between themselves, but once they're approached by the chair, they will come to an agreement. And this is my experience.
There has to be a level of trade-off, obviously, when you have 84 days to decide a dispute and you got to give a reasonable dispute. Obviously, you, as an adjudicator, you cannot put yourself to the strict rule that your decision has to be perfect. It just doesn't happen. You do not have the luxury of arbitration. You do not have all that additional time and the level of independent expert evidence that in arbitration it's pretty much the modus operandi. So trade-off helps a lot, and the more the dispute adjudication board is experienced, obviously the better will be the outcome in the manner in which they manage the process until the decision is given. What do you think, Florin?
Yeah, I do agree with that, and with that, I would also like to move to the second question, which Clive was mentioning earlier on.
Speaking of being short of time, so I think we should move on.
Okay, let's do that.
Question 2 is, of course, linked to question 1, or certainly the responses of question 1, and I would ask, on the basis of the discussions we've just had, how would the DB deal with its powers, its power or authority to establish the procedure to be applied in deciding such a dispute, its power to decide upon the DB's own jurisdiction and as to the scope of any dispute referred to it, its power to take the initiative in ascertaining the facts and matters required for a decision?
As far as I'm concerned, I'm absolutely fine with all these. As a DB member, you are empowered, you are in charge, you have to lead the process, you have to be proactive, you have to ask. As someone was telling me, I look at every case as to a boxing bag, and I go around it, punching it with questions. What if this, what if that? What about this hypothesis? What about that hypothesis? I put to the test all kind of hypotheses, and I test all the arguments of both parties. What if this that the contractor said is actually not right? What if, in fact, what the employer said is not correct? So I go and I test and I challenge each and every argument of the parties, of both parties, in order to be absolutely fair for both parties. And in my generally what I do in my decision, I describe this kind of assessment. I describe this kind of tests and logics which I applied, which in the end led me to a conclusion or another, which is in my decision. Why do I do this? Firstly, because, as I said, I must be in power, I must lead the process. That's why the parties appointed me as DB member. And secondly, because I have to show how did I took into consideration parties' arguments, what did I do with those arguments, which value did I give to these arguments, and then what was the reasoning, what was the logic behind which led me to a decision or another. In brief, this is what I am doing, because I think it is my duty to explain the parties why were they right or why they were wrong in one point or another. With that, I think I'm doing my job in helping them to resolve the dispute as quick as possible, or at least if they go further to arbitration or court or whatever, at least they know what was wrong with their initial position papers.
Rational reasoning.
Yeah.
Yeah.
But very good points. I think that the crux of every dispute adjudication proceeding is the procedure to ascertain the facts. And those, they need to be ascertained with a very high level of accuracy. Because if you get them wrong, you may give a wrong decision, and you may basically overstep your jurisdiction.
Oh, yes.
Create a situation that the decision will be invalid because you became a functus officio somehow, somewhere along the time to decide.
Yeah.
I find that the tool of being able to put to the parties questions after each set of submissions and allow the parties to reply within a reasonable period of time, it actually helps the rational reasoning of the dispute board. Without those question and answers, it is very hard, even if you are a standing board, to really get the gist of what the case is.
Mm-hmm.
Because, not all referrals are prepared in in a very structured manner. Sometimes language is an issue, and obviously they are not able to put forward their position in a very eloquent manner that the dispute board may understand. So you deal with the fact that you've got to test the evidence and the facts as you go along, and you got to ask questions. They have to be in writing, and on the basis of the answers, that's how your reasoning comes about.
Do you remember one case, Giovanni, where the respondent made the statement in his reply that the correspondence speaks for itself, and his submission was simply his complete correspondence file?
It is. You get all kinds of things. Look, I mean, depending who the parties are and where the contract has been performed, you can get from a very sophisticated referral with the submissions that are at level of arbitrations to something that obviously you will pull your hair out to try to make, head to toe what it's saying. But you can actually bring the evidence to you by asking the right questions. So it is important, the right question. I agree with Florin.
Yeah, and in the light of that, to answer the third question, I also believe it is the duty of the DAB, if they see some errors in the arguments of the parties concerning the time impact analysis or whatever else, about merit, about quantum, no matter. If you see any errors, I think it is the duty of the DB to raise them up to the parties and give them a chance to answer, and of course to the other party to have their own point of view on the matter.
Do you think a DB has the power to decide some provisional relief, such as interim or conservatory measures?
That is a very interesting question. We have to remember that the DB is not an arbitral tribunal, as Giovanni mentioned before. And again, if we speak in the light of the FIDI condition of contract, in my opinion, I see no procedure or rule that would allow for that. But if the parties do agree mutually that they would like to proceed with these kind of things, yes, it would be possible. But otherwise, I would be very cautious before going with this kind of solution.
I think it could serve beneficial for the negotiation period within FIDIC following a DAB decision. If the initial approach of the parties is claimant, I'm right, and the respondent, you are wrong, you're entitled to nothing, then that sort of 0 to maximum could be split by a DAB decision, which would bring the parties together to actually reconsider that maybe this claimant does have some entitlement. The DAB has awarded something, and therefore, if we go to arbitration, we may lose this case, and it may promote a negotiated settlement.
Yeah, I agree with you. If we are speaking about the whole dispute resolution process in total, then yes. If we are speaking solely about the adjudication in itself, yeah, then I'm afraid we would not have the chance to go with this kind of measures. But indeed, as I mentioned earlier, if a decision is properly argumented, is properly reasoned, and you explain the party, how did you get to a conclusion, to a certain decision, even if indeed initially they went from nothing to maximum, then in that period after the decision has been issued, yes, the parties would have, having this kind of the argumented decision at their disposal, they indeed, and if indeed they want to resolve the problem as quick as possible and as less costly as possible, then they could use this decision as a basis for their negotiations. Definitely they can.
One very quick last comment, Giovanni, because we have to close.
Yeah, well, the way I read the standard non-amended FIDIC procedures, they all allow for the dispute board to issue conservative measures and award financing charges. obviously, you have to be careful of what you do there. You can, because there can be some legal ramifications when you give conservative measures. They have to be interim. You cannot give a final order.
Exactly.
Not an arbitration. So if you give an interim measure, for instance, a party has terminated the contract and the other party is afraid that the employer, for instance, may call the guarantees, then if a dispute about the wrongfulness of the termination has been referred to the DAB, and the party that has referred wishes for the status quo to be maintained until a DAB decision is given, the DAB can give an interim order to the other party not to call the guarantees until such time that the a decision is given. And it can also instruct the contractor, for instance, to extend its guarantees if they would expire before the decision is given. For instance, if it's at the end of a project and a termination takes place, you may have the guarantees that they are close to their expiry life. So obviously, to maintain the status quo, FIDIC has cleverly put these powers at the disposal of the DAB to do it, but they need to be used carefully. So you've got to have an understanding of contract law and the applicable law that regulates them.
Yeah, I agree with that, Giovanni. Indeed, there are these kind of powers, but again, in my opinion, this provision in the FIDIC is not straightforward, is not explicit. It gives you a certain degree of powers, but exactly as you said, you have to be very, very cautious and be very sure when you go and apply that kind of idea, because as you said, if you do it wrongly, then you could simply go in front of the firing squad. Yes, you have a certain possibility, but it's not a straightforward instrument. This is what I wanted to underline.
And I couldn't agree with you more. It is an instrument that is at the disposal, but needs to be used carefully, because you may step over some aspects that some dispute boards do not have the legal background and experience to deal with it.
It's like a sword without a handle. If you want to use that sword, be careful what you do with the hand.
Thank you for your comments, gentlemen.
Thank you, Clive.
We look forward to any questions or comments from viewer attendees. And thank you, everybody, for participating.
Thanks, Clive.
Thank you.
Thanks.
It was a pleasure, my colleagues.
Bye.